which is Robert, is it Jenung versus Cynthia Jenung? 1003-2022.
Good morning.
Good morning.
Good morning again, Ruben. May it please the court. This is my first proceeding in the Appellate Court of Maryland. I knew you would smile. But I must confess, Your Honor, that you stated the greatest words that an appellate lawyer could hear. We have no questions. I'm afraid that will not follow me. This case, in summary, because you said you read the briefs, the extract, and the proceedings, is summarized. I was thinking my high school Latin class of studies of Gaul is divided into parts of three. Part one is there is no transfer provision requiring husband to transfer his interest in the home to wife. It's not in the judgment appealed. And I'm going to prove that. Part two is, if perchance the wife convinces you that it's somehow included in there by virtue of some dictionary definition or something else, then the question is that transfer provision either in error or an abuse of discretion, providing wife with 75% of the marital property and husband 25%, when the differential in ownership is husband owns $22,000 more of physical property, not cash, than the wife, meaning the differential, to make it exactly equal, not equitable, equal, would be a monetary award of $11,000, not a monetary award of $50,000. The third part, which is really interesting, the parties got divorced. This case is now going to celebrate its 5th year anniversary. And over 3 years ago, there was a divorce hearing that found the value of the house to be a certain amount. We'll call it, for the sake of argument, $130,000. At the last remand hearing, I offered to prove that the house is now worth $88,000 more because the wife had it appraised, and I offered that into evidence and proffered that. The trial judge admitted it as an exhibit and denied the entry. The theory that I said, it's in the record, and I preserved the issue, was that if you transfer the house, you're now transferring not only 75% of what was the marital property, you're now transferring 110% because you've included the post-divorce acquisition, which is non-marital because divorce ends the marriage, and therefore the acquisition is non-marital because it wasn't acquired during the marriage. Fortunately, I'm going to argue, you need not get to that exotic issue. You need not get to whether the monetary award, which is professed by the wife to be within the judgment, won't be an issue. Was it an error or an abuse of discretion? The abuse of discretion is that it exceeds the total differential of the difference in the marital property. We can rely on this. The judgment appealed is called the second supplement judgment of absolute divorce. All hands agree. I stated that in that judgment, there's no reference to any transfer provision. No reference.
Well, but counsel, that is because those provisions had been in the original decree of divorce.
Correct.
Correct.
That's right.
And that part of the decree of divorce was never challenged And if it was challenged, neither of the en banc panels reversed that part, correct?
Twice.
Twice.
So now, answer that directly. The first transfer provision is not the same as the transfer provision that was in the second order, which was the first supplement. So the judgment of divorce had a provision. It was vacated.
Was it vacated in full
That was
or in
vacated,
part?
absolutely vacated. And in Walter versus Gunther, the Supreme Court stayed, Your Honor, was the author. To vacate is to nullify. Therefore, the provision for the monetary award was a nullity. So when the en banc panel had it, it was a nullity. It sent it back to do. It was done. It was then en banc vacated again. Nullity goes
Well,
back.
it was sent back to the trial court for the trial court to articulate its reasonings as to the, its reasoning to come up with the monetary award, correct?
That's close to what it is. Close. Here's
Okay,
why.
where am I wrong?
Well, you're not. The closeness is that the en banc held that it should go back to redetermine any monetary award and division of marital property following Flanagan. It's right in there, and I'll read you the date and time that it was stated. This,
Are you now quoting from the record extract?
page 7 of the en banc, which is, I'll tell you where it is in the extract.
The second? Yeah,
This is
can you
right.
give me the
I have
page
it.
number, please?
I have, it's the, well, let me get my page for that. The, I think I have a,
The second en banc, was that on E89?
well, I'll get it.
Okay.
I have it right here.
Okay.
On page E 103,
103.
right above the word conclusion. We must find that an essentially 75-25 split requires further explanation. Your Honor's right. They want explanation on that, meaning the explanation under the law stating pursuant to Flanagan. This trial judge did not comport with Flanagan, and that's in the brief, and I'll point that out to you. So what happened is this. In the conclusion, E103, over to 104, the court, which is now essentially the mandate, states the case must be remanded to the trial court for further consideration of the decision regarding the division of marital property and monetary award. And the mandate, 105, requires the judge to follow that. I could argue that what Your Honor said is exactly what's in here, but it's obiter dicta. It is not the directive. It's the suggestion that when you do that, follow the reasoning, meaning under the factors. But when a vacated monetary award is retried, the trial judge is required to do it anew because there is no monetary award.
So your argument is that on the remand to the, after the second en banc decision, the court was required to have an evidentiary hearing?
The court, well, that's...
The trial court, I mean,
the
trial court was required to have an evidentiary hearing?
Well, there's a yes and no. The yes is yes in order to, as I cite the Fuji case, it's 3 years since the value of the house has increased by $88,000 by the wife's sworn admission, which I proffered.
Well, Fuji is a different issue. That's a different problem.
Exactly, correct. That's the yes part. The
okay.
no part is the trial court could just say, I have everything here, here's my decision.
Okay,
And
here's what the en banc panel said. In light of these parameters, we must find that an essentially 75-25 split requires further explanation by the trial court.
That's correct. And
But you equate explanation with a requirement to have an evidentiary hearing?
No, that part is not an evidentiary hearing. That part requires the trial court to determine first and foremost, there's no monetary award unless the court puts on the record, I determine the ownership of marital property is inequitable. Because you have to adjust the equities. Case law, and I cite that, 2 cases. You must say, I find it inequitable. The judge did not. The judge made no statement at the remand hearing other than you'll hear from me in a couple days, and I'll give you that cite. So what happened was there's no finding it was inequitable. If the judge had said, I find it's inequitable, he must find by his findings, because I point out the actual numbers from the en banc, which you'll find on E100 and 101, that the en banc is looking at 75.4% goes to wife, 24.6% to husband. Where's the equity of the differential of $22,000, meaning within that inequity, if the judge found it, a monetary award would be at most $11,000. What he did was give her $45,000. Actually, it was more.
Well, I want to get to the issue of the property. So on E98, the court says that the first en bancs, because the order that, or the memorandum in order that you're referring to, it actually starts on page 89, correct? And then it goes to 104, I think. But on 98, it says that the first en banc panel's order is silent as to the judgment transferring title to the party's marital home. Thus, the transfer of title was affirmed.
Right, and that was set aside. Right here, correct. They set it aside. Vacated. We need not dwell on what vacated means, I believe. Vacated means to nullify, set aside. And furthermore, Your Honor, to address what a judge can do on the divorce judgment, a judge, trial judge, cannot adjust any element of a divorce judgment of divorce, not the monetary award part. Grove versus George, 192 Maryland Ave. 428. So the trial judge knew this remand was not to do anything with the divorce, that was the title. So when you look at the 3 elements that I state, the body of the judgment appeal, the wife does not challenge, has no reference to monetary award or to transfer. The law is that if it's not in the 4 corners, it's not in there. Furthermore, the law is that a trial judge can incorporate by reference a prior order. It's in there. Wife agrees, no incorporation by reference. Furthermore, it's not even in the title. But the wife hangs her hat on is 2 dictionary definitions, Black, and the second one I think is Oxford. And I point out, the Black states any pleading can be supplemented. You can't supplement a judgment. Even Black's Law Dictionary, if the wife wants to call this a pleading and not an order, I'd be surprised. The second one says that you can supplement anything at it, meaning the prior, because there was nothing prior because it was vacated. You can't supplement a non-existing order. Now, when we look at the facts of the case, the wife does not challenge any authority that we propose in our brief or in our supplemental brief, and reply brief rather, that says this can be included under Maryland law without an incorporation by reference, without it being said again as required under any monetary award, because a remand for a monetary award requires all of the elements for a monetary award. Therefore, in conclusion, we think that we ask for an order, because you asked what is your relief, an opinion that says there is no transfer provision. The reason that the wife's pressing, she filed a contempt of court saying he hadn't signed a deed. She filed a motion to dissolve the, I'll use a few more minutes, thank you, of the application of lis pendens, so nobody can do anything with the property pending resolution. So the bottom line today on the first issue is, please consider the filings. As you said, this is a summary. The logic, the case authority is set forth in the briefing. Thank you.
Thank you.
Good morning, Your Honors. My name is David Ruben. I'm here on behalf of the Appellee, Cynthia Ganung. I guess I'll address it in order what counsel said were the three issues. First, he says that there's no transfer provision. As Your Honor said, in this first en banc review, the court indicated that because there was a transfer provision in the first judgment of absolute divorce, and they affirmed that in the first en banc, there was no need to repeat that. It's just a matter of semantics, I think, on all the issues that counsel's arguing, and the semantics weigh in favor of my client in this case. Supplemental is an addition to. There's nothing in Maryland law that I can find that says you can't supplement a judgment or amend a judgment, whether it's called amendment or supplemental. It's not what we call non-pro-tunc. I think that would be the term to erase it entirely. It's not that, and that was not the intention of either one of the en banc review panels. The intention was to supplement it. So was there a judgment of absolute divorce? I think counsel's saying at one, yes, there was. You can't vacate the judgment of absolute divorce, but he also said at one point, if they were divorced, then it became tenants in common, so then it would be non-marital property. But if they weren't, so they were divorced, there was a waiver of alimony or a denial of alimony. My client asked for alimony. She was denied alimony in the judgment of absolute divorce. That doesn't mean that that has to be restated, right, in the next order. So that's just semantics, and I don't think there's any value to that argument. So we quote what the word supplemental means, because we can use, as courts do quite frequently, a common sense definition if we're arguing about what that means. The court was not required to then again state that now that we've determined. So what Judge Cahill did at the end of his second opinion after hearing argument, he says, after he describes it entirely, and I don't have to go into that, I don't think counsel was arguing that, because as Your Honor said, the second en banc review simply said under Flanagan, hey, you, even though you stated that you considered the factors, in Flanagan it was 90-10, and this isn't 90-10, it's 75-25, but in Flanagan they didn't give, you have to articulate the factors. You do a little bit more than just state, this is what the factor is, and this is ultimately my decision. Judge Cahill said, okay, because he didn't do that, no question about it. I didn't appeal the second en banc review, because he didn't, I mean, it could have gone either way, but the en banc review said, hey, we need to understand, even though counsel for Ms. Ganung argued it, and you heard those arguments, we need you to spit it out, Judge, and tell us why, and articulate under the factors. And that's exactly what he did, and I don't even think that's in dispute. He went back and he said it's a 40-year marriage, and this
There's various forms of marital misconduct, for want of a better term.
That was, yes, that too. And that, but it wasn't just that, and I don't know that's necessarily the most important thing, but for Judge Cahill, it seemed to be important, but also that she made $14 an hour, and he had plenty of income, and this was the only home that she would be able to live in, and if it had been sold, she wouldn't have anywhere else to go. I think she was 62 at the time this occurred. So he articulated very well why he felt that an inequitable distribution, that'll my next argument is counsel says that the trial judge is required to say that it's going to be an inequitable distribution or not an equitable distribution. I don't agree with that. The monetary award statute says that the court will determine the equities of the parties, and there's nothing in there that says it has to be 50-50. I think that counsel's implying, as many attorneys and sometimes judges do as well, that there's a presumption of 50-50. We know there's not a presumption of 50-50. They just have to simply look and see how things are titled and make an equitable division of what is marital property. Clearly, there was enough marital property to make a monetary award of $20,000 or $50,000, however you want to call it. The judge had within his discretion to fashion that monetary award in a way that he felt was appropriate. There's no question about that. And so when he did that, he didn't have to say, I affirmatively find that transfer by virtue of title, which would have been 50-50, is inequitable, and therefore I'm doing this. He said that the provision that defendant pay plaintiff $20,000 as a marital award was an equitable adjustment. So instead of saying it wasn't inequitable, he said it was equitable, and that's completely satisfied.
And he used the term equitable.
He did. He did in both. I don't know that he did in the original one, but that, remember, was affirmed anyway, the actual transfer of the house. It just wasn't articulated properly. But then, after he says, and he says, the explanation, I mean, he couldn't have been clearer. He got the message from the three-judge panel on page 2 of his supplemental, the explanation, and he puts it in quotes, for the court's 2019 determination concerning the distribution of marital property is as follows, and at the end he says, the provision that the defendant pay the plaintiff $20,000 as a marital award was an adjustment, an equitable adjustment. And like I said, and I don't know that it's being challenged, but the court had absolutely within his discretion to fashion a monetary award that he thought would be appropriate under the statute and best help the client. So it wasn't a matter of, so in this case, the judge said, I'm going to order transfer title over to wife, which A205 and 15 years ago, I think it went into effect, gave the court the ability to transfer title even in tenants by the uncommon property. However, now that therefore I'm going to transfer title and wife is going to be 100% owner, I think it would be equitable to let husband have $20,000 of that, which roughly worked to be 25% of the 75. Totally valid. That's what equitable award is. That's what a monetary award is. The first time around, it was about the personal property that he didn't value properly. He did that the first time around. It wasn't appealed. So, you know, part one of counsel's argument, no transfer provision. It doesn't need to have another transfer provision. We go back to the order that says, in other words, maybe perhaps there would be a directive, although, because I don't want more appeals, this to be for 10 more years, that says that all of the judgment of absolute divorce, the supplemental judgment of absolute divorce, and the second supplement shall be read together. Sometimes we'll do an agreement and we'll say, as not to supersede the previous order for clarity, so that the circuit court, so that counsel or his client can see that, so we don't have to mess with that later. And then the third argument was Fuge versus Fuge, and I obviously, Your Honor read that case, and perhaps all three of you did, and that's a completely different issue.
Fuge, why doesn't this case fall under the Fuge versus Fuge? I'm not going to say it's a rule, because it's the remedy that this court ordered in Fuge versus Fuge. Why wouldn't that be applicable here under the facts of this case?
Because in Fuge versus Fuge, it was a matter of law, and it was sent for remand. And because I read it last night, I believe the issue was the interpretation of the new tenants by the entirety statute. And in that case, the real issue was whether or not the property sold prior to the divorce as T by E, but that at the time they got divorced, it was no longer there because it had been sold, but whether or not those funds that carried forward from the sale of the T by E property was marital property or not. That was the core issue, as I understood it, I think that was the second appeal, that's why it was so long, in the Fuge case. But, so that court, in determining what the law would be, because it was a new statute and that's how they interpreted it, remanded and said, we're going to have a whole new trial based on the issue, you know, all of the factors and all those things, because the original premise of granting the monetary award was an error of law, and therefore we're going to have to redo it. And then they went to the issue of, hey, it's been 3 or 4 years. maybe we should consider that there. So that's why that case was different. It was a complete remand, and if you want to call it vacate of the entire order, you can do that. This is different. This was simply articulation of the factors under 8205, not to take further evidence, and that's the difference in this case.
So let me try to rephrase this. So I think I understand what you're saying. Your suggestion is that Fuge, what was going on in that case was that the panel of, this court decided that because of this revision to the statute, the statutory remedy had to be applied and remanded it for the court to apply the statute.
I thought that.
I'm not trying to put words
No, I know
in
you're
your
not.
mouth.
I know you're,
I'm
but
just
I
trying to
think I have a
understand your
different.
argument.
I think I have personally a different understanding.
Okay.
And I thought that it was the question of whether or not tenants by the entirety property sold prior to the divorce remain, the proceeds from that sale, it would have to be because the property's not there anymore, remains marital property in then fashioning the monetary award at the time of divorce. And because the court said, no, it's not marital property because the T/E property, the lower court, the T/E property was sold, and that's wrong. I think that's what Fuge was saying. Preliminary, and then it went on to talk about what I know we're talking about, how do we value it down the road. But that initial issue in that case was a matter of law. And I think because it was a matter of law, they weren't telling the judge to articulate anything. They were saying, when you go back, you have to determine that as marital property as opposed to non-marital property, and therefore you have to redo the whole thing. And when you redo the whole thing, you know, you're going to look in that case at what the future value is or the present value at the later hearing.
All right.
Okay, articulated. Any questions based on that?
I understand now.
Okay.
So the issue of the panels vacating, you know, they use the word vacated.
They did.
You know, that Mr. Rosenthal hones in on because that's in their mandate, you know. And Mr. Ruben, I was taught that a mandate trumps everything. Way long ago in 2001 when I became a judge on the Court of Appeals. How does one differentiate? And taking aside Walter versus Gunther and all of that, in their mandate, they said vacate.
I don't think they did. If
okay.
we read the mandate as
Okay.
what's on page E105,
Okay.
which is the order, if we're calling that the mandate. We could also call the conclusion the mandate, but I think even more so, we call the order the mandate. It says the case is affirmed and in part remanded, in part for reasons as stated in the court's cost to be paid.
And so the earlier ruling, the 118, is that right? The one on 118?
Page 118?
Yes. They talk about vacating?
No, you're right. That's the,
This is where I'm confused, Mr. Rubin, because all I'd like you to do is address, you know, no matter whether it was vacated in the first or the second, okay, in some respects, if it were vacated in the first, that makes it even more confusing that they say in the second, you know, and I'm getting, and again, I may be getting my timing confused, but how do we reconcile the fact that they use that? Take aside what I said, and I'm not arguing Walter versus Gunn. That was a different issue. But, you know, in your line of work that I've been fortunate enough to get involved in, you know, those types of things are important. That word is important.
of course. And I think the answer is, where you're reading from page 118 is the first
Yeah, but that's what I'm saying.
But
if they vacated it in the first instance, if Mr. Rosenthal is right, then it didn't exist in the second incident. It wasn't brought back
you know.
Because it says judgments transferring, I'm sorry, I interrupted you.
Yeah, no.
It says judgments transferring
right.
personal property. It says judgments transferring personal property,
And awarding a marital award.
but not the transfer of the real property. And right above that.
Yeah, but it,
I understand. I understand it can be confusing. I get it, and to some extent, it conflicts with one another.
but isn't
But,
awarding a marital award include the transfer?
In it- But if you look at the paragraph above it, which is the last paragraph of that decision, they're affirming
Okay.
the trial court had the absolute authority in order for sale. I understand what you're saying. I don't have an answer to
I'm only saying a
that.
mandate, you know.
I
was
do. I
always
understand
taught
that, but we have to read it.
that the opinions are like,
I understand.
they're fluff, you know, that it's,
Yes.
and this was Jack Eldridge, okay, who taught me this, way back.
Again, I think there has to be.
Counsel, would you do me a favor? Let
Sorry,
Judge Pataglia speak. Don't,
I apologize.
No, it's-
again, I'm hard of hearing, and it's,
Right.
My fault.
one at a time.
Thank you. And I appreciate your transparency about being hard of hearing, because it's hard for me too, Judge Keough.
I'm
You know,
sorry.
it's hard for me to hear sometimes too, so I appreciate your transparency.
Well,
Thank you.
Thank you,
Anyway.
thank you.
So,
I'm not going to comment on that.
just if, the mandate in the first had that firm vacating, and it referred to the monetary award, and if the understanding of a monetary award includes a transfer provision, just if,
I understand.
what would you be arguing? Just taking those preconditions.
I would be arguing that the first en banc used the word vacate. We went back for a remand hearing after that one. We argued again. He considered again, Judge Cahill. He put out an order, and so that the first one we're not here for in the not Court of Special Appeals, the Appellate Court of Maryland.
Appellate Court, right.
Appellate Court of Maryland. We're not here for that one. So when we went to the second one, perhaps it's a waiver of arguing that at that point, and then Judge Cahill passed an order. That was an en banc review, so then that issue should have been dealt with then, but the second en banc panel considered everything, read the first one, recognized that the transfer was appropriate, and didn't feel the need to restate it, but the fact that they didn't restate it wouldn't indicate that it shouldn't continue to be valid, again, just because you don't have to repeat. And it can get confusing. I mean, in simplicity, it can get confusing when you have a trial and a three-judge panel, and a trial and a three-judge panel, and now we're here. So, nothing can be perfect, but then we have to use our common sense and practicality and all that. And the clear, what we're here for, I think, most importantly, is the articulation of the monetary award, not simply to be, I guess if you could send it back, you know what Judge Cahill's going to do because he's already done it. So we could use the harmless error in that sense as well, right? Send it back to him, and he already said it, he already articulated it, he already affirmed it, and it's just a matter of putting it in a judgment. So to the extent that you have the power to do that, to avoid that, and I don't know if you do, I think you do, maybe that would clear things up. But overall, we're asking that it be affirmed and the relief be granted so that my client can finally have that house that she's still in. Thank you.
Thank you.
In summary, on the send it back issue, if you send it back, please note, no reported case in this state has made a monetary award above 54%. 75-25 is unconscionable because if you follow my brief, page 5, husband would own half of the marital property of $67,000 plus that of $90,000. The wife winds up now with double the husband. The monetary award is not a punishment.
Our case law is pretty, I think, quite clear that if we change one part of the economic relief, we put back into play all parts of the economic relief. So
That's correct.
we would remand for the trial court to decide whether or not your client should pay permanent alimony, for instance, to.
That's very interesting. That was my next point. In determining the facts, because the trial judge said, I was asked to explain. So on page E3, the judge explains. On page 5, 6, I explain his explanation is wrong. The trial judge says, no evidence as to how or when the interest of marital home was acquired. Mr. Ruben said, you'll find on the top of page 6, the property was acquired by the mutual efforts of the parties. That's E7, transcript page 16, lines 16 to 20. The trial judge denied alimony, and in his opinion says that the wife was working 14 hours at $14 per hour, and the husband collecting $2,000 a month, disabled veteran. When you add it up, the reason she didn't get alimony was there's a differential in the income of $2,000 a year.
No, it doesn't matter, for the purposes of it doesn't matter why the trial court originally denied alimony.
Right.
But my point is that if we vacate the marital award and send it back, then what we typically do is we reopen alimony and any other form of attorney's fees, any other form of economic relief.
I agreed with Your Honor before. I agree now. I'm only pointing out that when we screen for error, part of the errors of the trial judge, with apologies to the poet, let me count the ways, the trial judge misjournalized the issues. When it goes back, if it should go back, that's alive and well. All issues on the table, correct. But in order to go back, we have to prove that there was no provision to do, and you just say there's no provision, goodbye, or we find out there's a reason to go back to the lower court, and that is for an error, and the error is either an error in the facts, and I allege errors in his findings of fact, which turn the case, page 5, and furthermore, the abuse of discretion. So I will stand firm on that I should win either. There's no transfer provision, and I've documented that, and I submit because you've all read that. Or if you find that the word supplement means something, because otherwise when lawyers supplement answers interrogatories, they say interrogatory, answer, supplemental answer. They must add to it. This document adds nothing to it. You can't transfer the title supplement to mean we're going to take something that which was voided twice. Thank you for your time. Mr. Ruben, always a pleasure.
Thank you so much, counsel. We appreciate your arguments this morning. This case is now submitted for our consideration. The court will be taking a 10-minute recess before we begin the next case.